The topic I chose to discuss was how media could block justice when it comes to court cases. And the particular case I chose was Rido versus Louisiana. It actually happened in the town I lived in Louisiana called Lake Charles um, in the early 60s. So Mr. Rido was arrested for a bank robbery, kidnapping of some of the staff at the bank, and the murder of one of them. Now, he was interviewed after arrested and before his arraignment or indictment. And he was interviewed for 20 minutes by the sheriff of the parish and two uh, state troopers. Well, the interview was recorded by KPLC, the local news station. And it had both video and audio. And during the 20-minute um, interview, it's not really clear at any point if Mr. Rido is aware that he's being recorded or if he has requested a lawyer or if he's even aware that he can have a lawyer. So, after the interview and the leading questions, he eventually confesses to the murder. And KPLC takes the recording and airs it 3 days in a row. Again, all before he's been arraigned. At his arraignment, he is assigned lawyers. He is given court-appointed lawyers. They immediately request for a change of venue. It is denied by the judge, and whenever they're trying to select jurors, it's almost impossible to find someone who has not seen this broadcast. Eventually, it goes to it goes to trial, and it is stated that the jurors, quote, had two deputy sheriffs, a cousin of the deceased, and the vice president of the bank, who also knew one of the injured kidnap victims. So, extreme bias on the jury already. Um, After the trial, the jury deliberated for a total of less than an hour. In less than an hour, they come back with a unanimous conviction for first-degree murder, and he is given the death sentence. Now, Mr. Rideout tries to appeal these. The first three attempts die in the lower circuit. On his fourth attempt, it makes it all the way up to the Supreme Court. The Supreme Court finds that, quote, yet in this case, the people of Calcasieu Parish saw and heard not once, but 3 times a trial of Rido in a jail presided over by a sheriff where there was no lawyer to advise Rido of his right to stand mute. So the Supreme Court found that his due process was not followed. He was essentially tried and convicted before being arraigned. And in the minds of the individuals in the parish who had seen this for 3 nights before the trial even began, everyone assumed that he was guilty because of this confession. It set the precedent in the Supreme Court that a presumption of prejudice should be applied if the media is an active participant in pretrial. So if there's a ton of pretrial coverage, speculation, throwing out evidence that may or may not be admissible, you should presume that in that area, jurors will be compromised. And a change of venue is in order. But it didn't end there for Mr. Rido, unfortunately. He was tried 3 more times, and he was convicted all 3 times by all white juries. And he would appeal, it would go back down, he would be commuted. His third one stuck. He was on death row at Angola prison in Louisiana. And it was eventually commuted because of another Supreme Court case that was about. So essentially, the laws in Louisiana were arbitrary with the death penalty. They were thrown out on a lot of crimes with no real consistency. It was just kind of haphazardly added on, and the Supreme Court said that those laws weren't allowed. They weren't allowed to do that practice. So he was eventually commuted to life in prison as opposed to the death penalty. Um, while in prison, Mr. Rideout began going to classes and reading in the library and educating himself, and appealed again because his third conviction happened in 1970, which was after the civil rights laws had been passed in the late 60s, and there were no blacks on the grand jury that indicted him. Mr. Rideout argued that this was in violation of those laws as they were still barred from participating in grand juries, and the circuit court agreed with him, and he was released. Well, again, in the 2000s, he was tried again for the crime, this time with a diverse jury, and he was eventually convicted of the lesser crime of manslaughter. In Louisiana, manslaughter can have a maximum of 21 years served, and he had already served well over that. So he was immediately released for time served. Now, is what could have deterred this best, I would say, would probably be social programs in the area. The area in which he lived in Lake Charles was and still is very poor. Um, that area has very little business beyond shopping. There's really no industry near it. And at the time, it was massively segregated. Um, it is the early 60s in the Deep South, so that's no surprise. But any form of community outreach or a mentorship program could have done very well. Community outreach usually does well in general, let alone for poorer regions where people are trying to find ways to get out of it, regardless of the steps they need to take to do so. Um, Another thing that could have been done would be just better education in the area. Um, like I said, it was a poor region, so the school that he attended did not get a lot of state or city funding, and got even less because it was an all black school in the early 60s. So he was really poorly educated, and like I previously stated, most of his education came while in prison on his own, teaching himself. Um, and the correlation between better education and lower crime rates is very well studied. But as for what the defense could have done, the easiest fix would have just been to agree with the change of venue. They were fully aware that the jury pool in that parish would be tainted. Um, there was really there's really no justification for why it should have stayed in Calcasieu Parish. Um, they had plenty of witnesses. I mean, it was a bank robbery. Um, and the other two individuals who were there, the other two who were kidnapped, excuse me, along with the deceased, were also battered. One of them was shot, and the other one was stabbed, and they played dead essentially, so that they wouldn't kill, so that Mr. Rideout wouldn't kill them as well. And That in itself is enough evidence, especially at the time where witness scrutiny was a lot lower. They were so hyper focused on the interview and the confession itself that they completely disregarded that it was tainted. Um, he had no lawyer. It wasn't even a it wasn't even apparent if he knew it was being recorded or if he had the right to have a lawyer or the right to just not talk. Um, a lot of sketchy practices, which, to be fair, was kind of on par at the time. Um, Now, a change of venue may not have really done a lot when it comes to jury selection because a lot of blacks in Louisiana at the time were disenfranchised, and if you can't vote, you can't serve on a jury. So it more than likely would have been an all-white jury in another parish. However, if you moved far enough away, you wouldn't have had them be as aware and know about the confession and have seen the broadcast. That would have been a way to kind of secure their camp because they had, I mean, witness testimony, people who saw the murder who were also attacked themselves. There was no need to lean on the confession as they did, and that ended up coming back to burn them. That's really the only thing they needed to fix beyond the jury tainting with the broadcast. They had a solid case. So in fixating on a specific piece of evidence, they ended up destroying the entire case. And it would really just get the change of venue. That's all they needed to do.